Hey everybody, it's Nick Lydorf. How you doing? It's episode 68, I believe, of Off the Clock. I wanted to talk to you about this sovereign citizen complaint that I received from someone. It was entitled "Complaint for Arbitration," and it involves this fake arbitration association called Sitcom Arbitration Association, which is just some like made up company that you can basically pay to arbitrate or create documents that just are kind of made up. It's wild. So you should check out their website. It's pretty interesting. A lot of their documents have been taken down. I don't know why. Probably because possibly they are making stuff up. Possibly, it seems that way. But so I got this. So I want to share this document with you, and we'll take a look at it. I may have to do a couple of parts of this, but this is a wild document. So you can see that. Let's see. So this is just called Complaint for Arbitration. It was someone emailed this to me. So this is the instant matter. This is just, a lot of it's just completely gobbledygook. This is in Latin. I tried to translate it. It's like for the person that sues in the name of the king, something. It doesn't make any sense. Then, so the document as a whole, it's 30 pages long. Each page is initialed and there's a fingerprint. And it would be great if it was in blood, because that would make it even more wild, but it's probably not. It's probably just red ink. But so this is an action that this guy filed. His name is, let's see, there's a court case about it that I'll talk about either today or in another one, but it's Jerry Allen King, and he's the plaintiff, versus Donald Trump, John Roberts, Nancy Pelosi, Charles Grassley, William Barr, United States of America defendants. It's interesting that those are the only plaintiffs that the only defendants that they picked. They just picked those people. It's very interesting. So it's and then the respondents are like this list of defendants that, let's see, any political subdivisions, instrumentalities of any nature, government of the United States, aka United States government, aka doing business as the United States of America. So they're basically, you see where this is going. They're alleging that maybe the United States is doing business as something else, that maybe they're a corporation. I don't know. I want to go through this and parse through it, but I wanted to do a live video here today, so I wanted to do that. There's the initial and the fingerprint. Ooh, spooky. And then kind of goes through all this stuff. Charles Ernest Grass, and then names all the defendants and gives them all their like saying that he's doing business as the United States Senate, or also known as Office of the Senator. It's wild. Jump into the bottom of it. When they sign everything, the way that they sign it was interesting. So they signed it on the 12th day of June in the year of our creator, 2019. Then it's signed heir of the creator, comma, real man, living soul, secured party, holder in due course, real party in interest, grantor, bailer, administrator, creditor, custodian, beneficiary, all rights, privileges, freedoms, and immunity hereby claimed, reserved and exercised without limitation, without prejudice, without recourse. All those titles. That is wild. I don't have any those titles. I'm just a lawyer, I guess, and probably according to this, I'm probably just a sucker because I just follow along with whatever the government tells me to do. And then they signed it, and then they put their fingerprints on it, because no one's ever asked for anything having to do that. That makes no sense. There are also a lot of footnotes, and I gotta go through this document because, let's see, there's 473 I guess these would be end notes because they appear at the end. Wild. They take up, let's see, about 60, almost 15 of the 30 pages. Then there's statutes that are cited. It's crazy. These are just at page 3. We're still listing the defendants. Oh, here we go. This is a pure contractual dispute with the authority for arbitration or neutral disposition in a judgment contained within the contract. J13, I don't even know, as the sole and proper manner in which to resolve this matter. Therefore, jurisdiction is contractually decided and proper. So what this person did is, like, they filed a complaint with this arbitration association, which is allegedly made up. It's called Sitcom, SITCOMM Arbitration Association, and you can find them online. And they asked for a $6 billion award against President Trump, Nancy Pelosi, Senator Charles Grassley, John Roberts, all these people. And then they filed this in federal court in the United States District Court of the Southern District in New York. And then that meant that that court had to review it and make an opinion on it. And it's wild. I will try and add the link to the court opinion in here, but basically the court had to deal with and write an opinion, and said that basically this whole thing is frivolous, and dismissed it. And the guy, this guy actually had counsel and was not in, I think he's in prison. He was in prison at the time of at the time they wrote the opinion, either Greenhaven Correctional Facility. I don't know where that's at. That could be jail or prison. But they said that this is basically some frivolous lawsuit, and, they dismissed it. And, without a doubt, like, if this guy actually had some means to pay attorney's fees, I'm sure that the court would have hit him with attorney fees for having to respond to this. They filed a $6 billion request for a reward. How do you come up with $6 billion? $6 billion? Why not just go for like 100 billion or like $1 trillion? Why would you just settle for 6? Maybe I got to read through this and figure out. Let's see some of the highlights here. So the discussions, the plan for lies. That's the guy that's incarcerated. Plan for lies on a purported arbitration award from Sitcom Arbitration Association, which is an organization that many courts have described as invalid. Then they cite some decisions that have reviewed some of their awards. Court decisions have described the Sitcom Arbitration Association as engaging in the following. They use in quotes, which is kind of like a nice sarcastic way of putting it down. They engage them in the following procedure, which probably isn't a procedure at all. Petitioner obtained an arbitration, quote, hearing by sending respondents an incomprehensible agreement to arbitrate and using their non-response to initiate an arbitration. So you paid some sort of fee to start an arbitration with somebody, to send them a complaint to the other party in the arbitration. It was completely nonsensical. The other party didn't respond to it. And then they got some sort of ridiculous award. And then they're trying to enforce that award in an actual court, which is wild to me, because I thought they didn't believe in, certain sovereign citizens don't even believe in these courts are maritime courts or courts of limited jurisdiction, so that it's that they can enforce some sort of arbitration award. It's kind of interesting. And then the court kind of goes through some of these cases. So one court's nice. It says district courts generally grant a pro se plaintiff, which is a pro se is a person that's not a lawyer, that's representing themselves in a case. So district courts generally grant a pro se plaintiff an opportunity to amend a complaint to cure its defects, but leave to amend is not required where it would be futile. which means this is so ridiculous. We're not even giving you an opportunity to even to try and fix it, because it's just insane. This is wild. Because the defects in plaintiff's complaint cannot be cured with an amendment, the court declines to grant plaintiffs leave to amend and dismisses the action as frivolous. Then it says the clerk of the court is directed to mail a copy of this order to plaintiff and note service on the docket. Plaintiff's complaint is dismissed as frivolous under 28 U.S.C. section 1915. Court certifies under that same statute that an appeal would not be taken in good faith, and therefore IFP status is denied for the purpose of an appeal. So interesting. And when I first read this complaint for arbitration, I was like, wow, this is wild. I'm going to parse through it a little bit more and get some of the highlights for you. But it was interesting to see that it's King versus Trump, because they just put the first plaintiff and first defendant. And you can find it. It was decided on December 8th, 2020. And the case number was 20-CV-9268 CM, Southern District of New York. I don't think it was published because it probably wasn't worth for them to want to publish the opinion. But yeah, I just want to do a quick video on that. Make sure you check that out. That is, it's a good read. I'll try and link to it in the description. And come back tomorrow night at 7 p.m. and I'm going to talk with Natalie Lawyer Chick. I'm sure the topic of sovereign citizens is going to come up, and we will laugh about that. So I hope you have a good rest of your day. And